Okay, McDonough versus Homestead.
Dr. McDonough, the pro se plaintiff, Your Honor. Good morning.
Good morning.
Good morning, Your Honor. Sam Zeskind, the voice of Rhoda Healthman for the defendant, City of Homestead. My partner, Matthew Mandel, is on as well.
Got it. Mr. McDonough, it's your motion. You want to proceed?
Yes, sir, Your Honor. From the outset, it's noted that I'd like to incorporate my verified motion and verified reply into my arguments here today. Your Honor, if it pleases the court, before addressing the merits of the motion, I feel that another issue must be first addressed. At the last hearing, Mr. Zeskind argued that my motions could not be granted without an evidentiary hearing. Though I sternly dispute this, it's the only relevant defense that I've seen them present. Therefore, in the interest of judicial economy and to avoid delay or prejudice to any party, I respectfully ask that we, one, convert this into an evidentiary hearing, two, reset both motions for an evidentiary hearing, or three, hear my arguments as to why the cited authority actually shows that an evidentiary hearing is not required. The arguments as to why no evidentiary hearing is needed, as well as my primary arguments, I expect to take about 2 to 4 minutes each, and I don't know how you would like me to proceed with this, Your Honor.
I will not grant you an evidentiary hearing today. If you believe this needs an evidentiary hearing, you can set it for an evidentiary hearing. It's your choice. The question is, are you entitled to it? I don't know what the response is going to be. So right now, this is not the process for an evidentiary hearing. So I will not address. I will deny that request at this moment.
Okay.
Okay. So if you want to proceed, it's up to you. If you don't, it's up to you.
No, I want to proceed, Your Honor, and I don't believe an evidentiary hearing is required, so I'll just quickly try to get through that and explain why it's not needed. Furman v. Furman was cited for the proposition that an evidentiary hearing is required. However, at 1282, the court stated, quote, "The husband argues that by requiring full disqualification of his attorney and by ruling on the motion without an evidentiary basis to do so, the court departed from the essential requirements of law. Because the husband's argument focuses on the latter, we begin with the argument that the court granted the unsworn motion without holding an evidentiary hearing or otherwise having an evidentiary basis to grant the motion," end quote. Your Honor, first, I'm not seeking full disqualification of Mr. Zeskind, but only to the extent that his actions as a witness and advocate could prejudice this court or myself.
Okay, Mr. Doctor, let me stop you.
Sure.
This is a motion to pierce attorney-client privilege based on fraud.
Yes, sir.
So that other hearing's already gone.
Okay.
I'm still dealing with that.
Yes, sir.
But let's focus on this one so I can actually get the gist of it. I read your motion. I read the response. So go ahead.
Sure. Yes, sir, Your Honor. Your Honor, during the prior litigation of Request A, Mr. Zeskind wrote to a colleague that he had recommended, presumably to his clients, that they not fight the issue of refusal to produce responsive invoices. Can I show you this email, Your Honor? I cited as Exhibit 3 in my...
It's I got all your exhibits.
Okay. Therefore, Your Honor, I have a factual basis showing that the City of Homestead knew the withholding of the invoices was unlawful during the litigation of Request A. However, Request A was then refiled as Request 1, and Homestead again moved to withhold the invoices as well as other responsive records, even after the request was broadened, Your Honor. In doing such, Homestead has again sought the services of Mr. Zeskind to enable or aid it in perpetuating what it clearly knew by this time was a crime or a fraud. There's a factual basis beyond conclusory allegations showing prima facie proof of the existence of the exception. Mr. Zeskind has failed to meet his burden of persuasion to refute, address, or explain the factual allegations made within the verified amended motion to pierce privilege. Also, the recent case law cited by Mr. Zeskind in his notice of filing, I believe, is instructive and supports my case as well, Your Honor. Therefore, I respectfully request that this honorable court enter an order piercing the attorney-client privilege and compelling Mr. Zeskind to sit for deposition so I can properly prepare this case for trial.
Okay. Ms. Zeskind or Mr. Mandel, who's going to argue this?
I will, Your Honor.
Okay.
As to the very first point that plaintiff raised, I think that it dovetails with the issue in general, and that's that plaintiff has wholly failed to satisfy the elements that are necessary to obtain the extraordinary relief that he's asking for, which is to pierce the attorney-client privilege between our client, the City of Homestead, and myself, in terms of what may or may not have been discussed in litigation that concluded 4 years ago when the third DCA ruled in favor of the city on all issues. including the issue that Mr. McDonough claims to be the quote unquote crime or fraud here, which is interpreting two different public records requests differently and producing records in response to one request as opposed to another. But I would just like to point out the Butler Pappas case that we cite in our response. The third DCA in that case laid out precisely what the elements are that are needed in order to pierce the attorney-client privilege. And there's 4 of them. Dr. McDonough has not satisfied any of them. The first step is that first he must specify the crime or fraud. He's not specified a crime or fraud. What he's specified is a differentiating interpretation between 2 different public records requests. It's not a crime or a fraud. In fact, that differing interpretation, the third DCA agreed was properly interpreted and that the city acted properly in responding to the public records request in that case. The second step, if he's able, let's say Dr. McDonough was able to actually specify a crime or fraud that's occurred, what the third DCA says is that the second step is that he must make a showing, he must proffer evidence that the city, or the client here, the city, actually sought the advice of counsel in order to further the attempt to commit that crime or fraud. That step is completely skipped here. There's no evidence that there's been any advice sought of counsel in the furtherance of any crime or fraud. If you were to satisfy those 2 elements, which he hasn't, Your Honor, then at that point, the third DCA says that the third step is that Your Honor would have to conduct an in-camera proceeding. Now, because we're not talking about Your Honor's review of any email communications here, any written communications, that in-camera review would instead have to be Your Honor talking to me about what I might have spoken about with our client during the prior proceedings. And then finally, if Your Honor, after conducting the in-camera review, believed that there was reason to examine this further and that the crime fraud exception would apply, then at that stage, after the first 3 steps have been satisfied, then an evidentiary hearing would be held. And at that time, the city would be required to respond to the allegations. At this point, there's no burden on me or the city to respond to the outrageous allegations that plaintiff has made. The burden is on him. He hasn't satisfied the first element. He hasn't specified a crime or a fraud. And then secondly, he hasn't identified any instance where there's been any communication in order to further any attempt on a crime or fraud. Instead, what plaintiff is relying on here, Your Honor, and it's purely a litigation tactic, he's trying to relitigate the case that the city prevailed on 4 years ago by submitting a verbatim identical public records request that's the subject of this case to the one that was already decided, is that he wants to take my deposition. He wants to find out why he lost the last case. And he thinks that it's not because he lost on the merits. He's trying to throw up smoke and mirrors and have Your Honor allow him to take my deposition to satisfy some concern that he thinks he has about how that case was decided. Right. But Your Honor, what he's relying on is a communication between myself and one of my law partners, the appellate partner, who was the lead appellate attorney on that case, where we're discussing revisions made to a draft of a brief that was filed and how a particular argument is a close call. And I reference advice that may have been given during the course of litigation, not having anything to do with the response to the actual public records request, which is what is required here. And the distinction, again, that was being made in that correspondence that was made in that case, the distinction between one request where he asked for records related to the city's decision to provide a defense to one of its police officers, as opposed to a broader request where the city asking for all records related to the city's actual defense of that officer in the case. The third DCA ruled on that. He's trying to relitigate that issue here.
I got you. I
Where
got you.
GCA's role.
You're repeating yourself. Anything else you want to say?
No, Your Honor. Only that plaintiff has not satisfied the elements necessary to pierce the attorney-client privilege, and his motion should be denied.
Doctor, you get the last word.
Yes, sir, Your Honor. My allegations aren't simply the email. I think that's the clearest evidence. If you read the email, they were working on the appellate brief, but Mr. Zeskind is completely having a lack of candor in describing what that email was. He specifically said that he recommended at the outset, before they ever even had the hearing, not to fight that issue. Presumably, he told his clients that. So when he told his clients that in the first case, at that point, they should have known it was unlawful. When I refiled the request after the exemptions expired and they hired Zeskind again and they refused to give me the records, they sought Mr. Zeskind's services to commit or perpetuate what they clearly knew was a crime or a fraud, Your Honor. In addition to the email, Mr. Zeskind has also failed to respond to the fact that he has twice now presented a false, knowingly deficient privilege log. In terms of him alleging that I have not met the elements of the claim, I completely disagree, Your Honor. I specifically specified the crime in my motion. It was the knowing withholding of public records, which is a misdemeanor under Florida Statute 119. I also believe the withholding or concealment of the records was done with corrupt intent to provide gain to their clients and harm to me, which is official misconduct under Florida Statute 838022, Section 1, Paragraph B. The last thing I'd like to say, Your Honor, is I don't want to depose Mr. Zeskind to find out why I lost the last case. I know why I lost the last case. I want to depose Mr. Zeskind to make sure that his knowingly false statements made in the prior litigation do not contaminate this litigation, Your Honor. And with that, I rest my case.
Your Honor, you're muted.
Sorry. Is there another motion that I have to hear on this issue, similar to this issue? Or is this the last one?
This is the last one, Your Honor. The motion for disqualify and the motion to pierce are kind of
I thought there were three. So
our motion to dismiss his declaratory and injunctive relief counts is set for next week, but that's not related to.
Okay. I'm going to withhold ruling on this issue. I'm going to put it together with the other issue and determine what I'm going to do.
Your Honor, if I could just add one more point, plaintiff just mentioned records being withheld from him and that being the basis of the crime or fraud. I would just like to remind the court, and we advise the court as much in our response to the alternative writ that was issued in the mandamus count, that all the records that plaintiff has identified in his complaint, whether they were responsive to his actual public records request or not, he's in possession of. They've been produced by the city. So all of this is moot. There's nothing to even, no further judicial labor is even necessary on this case. There's no reason for any depositions, let alone the taking of my deposition.
That's for another day. Okay. Thank you very much. I'll send you an order on both motions.
Thank you, Your Honor. You have a great weekend.
You too.